Welcome to the 14th meeting in 2025 of the Delegated Powers and Law Reform Committee. We've received apology today from the Deputy Convener, Bill Kidd MSP. In his place, can I welcome Rona Mackay MSP. I'd like to remind everyone to please switch off or put to silent their mobile phones and other electronic devices. The first item of business is to decide whether to take items 5, 6, 7 and 8 in private. Is the committee content to take these items in private? Yes. Under agenda item number 2, we're considering an instrument subject to the negative procedure. No points have been raised on SSI 2025-108. Is the committee content with this instrument? Yes. Under agenda item number 3, we're considering an instrument not subject to any parliamentary procedure. No points have been raised on SSI 2025-107. Is the committee content with this instrument? Yes. Under agenda item number 4, we're taking evidence on the leases, automatic continuation, etc. Scotland Bill. And before we begin taking evidence on the bill, I want to put in the record that all members of this committee rent office premises in our capacity as members of the Scottish Parliament. While this does not represent a declarable interest in the bill, we want to put in record this fact, given that the subject matter of the bill concerns commercial leases. For our first panel today, I'd like to welcome David Bartos, the former Lead Commissioner, and Rachel Rayner, the Chief Executive of the Scottish Law Commission. Welcome to you both. Before we begin, David, on behalf of the committee, thank you for your contributions as Lead Commissioner on the report on aspects of leases termination during your 5-year tenure at the Scottish Law Commission. We know certainly, I think you clearly enjoyed that particular piece of work, and obviously the fact we'll get the bill in front of us today, so we want to thank you for that. So before we start, can I remind you both that not to worry about turning on the microphones during the session, as these are controlled by broadcasting, and if you would like to come in on a question, please raise your hand or indicate to the clerks. And also, there is no need to answer every question. Simply just indicate this isn't for you to respond to. However, please feel free to follow up in writing to any question after the meeting if you wish. So we'll now move to questions. I'll open before handing on to colleagues. So first of all, can you summarise what the main problems are with the current law on commercial leases and how this bill seeks to address these problems?
Thank you very much, Commissioner, and also for your earlier kind words. The area of commercial lease law that we're concerned with relates to the termination of commercial leases. In other words, what has to be done in order to bring them to an end. And there are a number of difficulties with the current law. First and foremost, the law itself is difficult to find. In order to find a definitive statement of the law, one has to go back partly into 17th or 18th century texts, perhaps modern texts, some statutes from the 19th and early 20th century, and a scattering of case law. It is not straightforward to obtain a statement of the law, and indeed the modern textbooks have found it difficult to do so. Tied in with that is the second issue, which is uncertainty in the law. It is said that the law operates satisfactorily in practice. It may be that practice operates reasonably satisfactorily, but the underlying law is vague. As an example, it is unclear whether parties can, in their lease, exclude tacit relocation from applying. In other words, whether they can choose to have a lease end, for example, without a notice to quit. That's a very important thing, and the law is really quite unclear on that matter. The consequence is that in practice, for example, notices are always given, even though they might not at all be necessary. Tied in with all of this is then the third difficulty, which is that the law is outdated. A couple of examples suffice. One is the requirement that notices to quit be given no later than 40 clear days before the end of a lease. Now, the purpose of a notice to quit is essentially to allow the tenant to relocate find other premises if necessary. 40 days seems to come from the depths of the 16th century. Perhaps it was suitable then, but few would say that it gives sufficient time in this day and age. And another example is the requirement of the 1907 Act that notices be given by recorded delivery. And again, that is something which may be followed in practice, but is unnecessary and outdated. So those are examples of why, in this instance, reform of the law is necessary. In terms of the background, the Commission was approached way back in about 2010 by practitioners, solicitors in the commercial leasing area who indicated that this law should be reformed as it was uncertain and was acting as a deterrent to commercial property investment. Essentially, the point was that the difficulty in explaining the law meant that it wasn't clear for commercial property investors on whether they could obtain fresh tenants or not, or obtain vacant possession for redevelopment or not, and matters of that kind. So that explains the difficulties in the current law.
Thank you. Can you explain why the decision was taken not to abolish tacit relocation as the default law for commercial leases?
The Commission consulted on this matter, and there were some who expressed support for abolishing tacit relocation in the sense of a notice to quit being required before a lease could come to an end. However, the majority view was that, of the consultees, that tacit relocation for not giving notice should continue on the basis that the giving of notice could act as a safety net, as it were, reminding a tenant that the lease is going to be coming to an end and that they need to do something about it. I think that view was probably bolstered by the fact that we have had the notice to quit requirement for hundreds of years. So overall, the view was taken that there was still sufficient merit in having tacit relocation for not giving notice to quit.
So certainly you touched upon there regarding the also being contacted in 2010 and your comments there regarding also my initial question, but certainly some of the evidence which you did reference which had the opposing view. So Burgess Salmon, for them, they felt as if the law on giving notice is clear due to the Rockford case. The Faculty of Advocates felt as if a thoroughgoing reform of the law on tacit relocation is not needed. They also thought that the new statutory code will be broadly similar to the existing practice. And the Law Society, yourselves obviously, Rachel, possible confusion as the statutory code will operate alongside the common law during the transitional period in Part 2 of the schedule, which also we will come on to. And also the statutory code will be less flexible than the common law.
Well, if I can maybe take those one by one. So far as the clarity of the law is concerned, it has been an interesting situation where certain firms or certain individuals within them have expressed the view that the law is clear, but our researchers at the Scottish Law Commission indicate that that is not fundamentally the case, and if anything, what is perhaps clear is the practice rather than the underlying law. So one option would be to keep the status quo, to keep an unsatisfactory law on the basis that there is a practice which effectively disregards it, but that did not seem to us to be acceptable, and indeed not acceptable to many other stakeholders. Turning to the second, and indeed in terms of the views on the Rockford case, which I think was mentioned, different views have been expressed as to what the Rockford case actually entails. Some stakeholders have actually favoured the outcome of the Rockford case and others have opposed it, owing to the fact that it causes uncertainty in negotiations whether in that case the tenant has given notice to end the lease that they're going to be leaving or not. So there are divergent views over the Rockford case. Turning to the matter of the code, what the Commission could have done is simply left the various strands of the law as they are, coming as they are from the 16th century, coming 18th century case law, and then try to bolt onto that some changes. But it seemed to the Commission and indeed to the stakeholders that it consulted on the code issue that it was better to simply bring all the law into one place and create clarity in one place. That way it deals with the accessibility issue, the difficulty of actually finding the law here. And that's particularly, the importance of the code, I think, is particularly relevant to the modern day because a lot of these old texts are not to be found online. A lot of lawyers will do their business online, but a lot of these old texts aren't online, and finding the relevant passages in them, one has to refer to other textbooks. It's a difficult, or can be a difficult process, and putting it all in the code makes it easier. Yes, the code will not be perfect, but no code ever is.
That's true. Okay, well, thank you very much. Round over to Ros McCall.
Thank you, Convener. Thank you, Convener, and good morning and welcome. Can you explain what the rationale is behind the definition in the bill of the leases to which the legislation will apply?
The rationale is to deal with leases which can be described as those which are commercial in the sense that they are not regulated. So the task of the Commission was to reform the law for commercial leases. So it had two options before it. One was to create a new category of commercial leases with a new definition. And it appeared that that route could in fact create greater complexity and potentially confusion in the law. It would create a new boundary between commercial leases and non-commercial leases, which doesn't exist at the moment. Instead, it seemed more straightforward to keep the existing boundaries that already exist between regulated leases, by which I mean, for example, private residential leases is a classical example, or indeed the public sector, public residential leasing sector, the agricultural sector, crofts. I think there are some allotments as well, and to exclude the reform from those and keep it to the unregulated leases, which are predominantly commercial. One caveat to that is that there were some leases, typically residential ones, which are currently not regulated, but where the Commission thought that there wasn't a sufficiently commercial element to make it appropriate to apply this code to them without further consultation. And those are the leases, I think we can see them, I think there's asylum seekers leases, homelessness leases, they're listed in section 1. So those will not be covered because they don't have a commercial element.
Okay, thank you. That's great. So you mentioned the agricultural, and we've certainly had a couple of submissions that have come in. There would be some issues sort of on that rural position, especially when it comes to mixed-use land, tree nursery, forestry, grazing, mowing leases, that sort of thing. So what's your response to the committee's call for views arguing that definitions need to be tightened in relation to matters such as that, or that clarity is needed that the bill only applies to heritable property?
Well, so far, taking the last one of these, I'm speaking personally, I have no objection for clarification that it applies only to land and buildings. So that is a drafting matter. So far as the boundary between leases that are covered by the bill and leases that are not covered by the bill, though that boundary already exists between leases covered by the common law and these strands that I mentioned, and the separate regulatory regimes. So basically what you do at the moment, for example, in relation to mixed use, say for agricultural purposes, the business and non-business, is that you apply the tests in the Agricultural Holdings Acts. These acts already exist, and they decide whether the acts apply or not. They will continue to apply for this bill in that they will decide whether the acts apply, in which case this bill doesn't, or the acts don't apply, in which case this bill will.
Okay.
I hope that
that
explains it.
Very helpful. Thank you very much. Thank you, Convener.
Okay, thank you. Jeremy Balfour.
Good morning, and again, thank you for coming along this morning. I mean, we're moving on, maybe just to look at sections 2 to 7 of the bill.
Yes.
Which is the statutory code. I suppose what I'm interested to know is, in practice, how will this work, day to day?
Well, in practice, the starting point is when a lease is entered into. And if a lease is entered into, there will be a possibility that it could include a clause which excludes the need to give notice to quit altogether. So that could be included within the lease. It'll be up to the parties to negotiate whether it should be there or not. So that's the fundamental effect of Section 4. If it is not included, then in that case, the lease can only be brought to an end if there is a prior notice to quit or notice of intention to quit. And in those circumstances, in terms of the code, there are rules as to when a notice to quit has to be given, or a tenant's notice of intention, the form it has to be given, and how it is to be given. And in terms of so that deals with automatic continuation with a clause. Automatic continuation without that clause being present. Sections 5 and 6 deal with a situation which can exist in any event where the tenant remains after the end of the lease, and for it typically pays rent and the landlord accepts rent, and parties behave as if the tenant is still in a lease. And what those sections do is they regularise the position of the tenant. So in other words, the lease is automatically continued in those circumstances, and they can happen whether a notice to quit is given or not given. So there are, in fact, strictly speaking, two different types of automatic continuation. There's the type which happens if no notice to quit is required and is not given, and then there is the type that happens irrespective of notice, where the tenant remains and parties treat the tenant as remaining. One other matter I should mention, because it was raised by one of the firms replying to the committee's call for evidence, concerns termination where, this is where no notice has been given, but where the tenant gives up possession of the subjects of the lease with the acquiescence of the landlord and in circumstances which indicate that both parties intended the lease to end on that date. Now, that provision reflects what is already currently the law, the common law. It's reflected in the, I think, Dundee City Council against Dundee Valuation Appeal Committee case, where effectively it was said that the lease could come to an end, provided that the tenant left and handed over the keys, and the keys were accepted. So that's another example where the law currently allows lease to come to an end, and effectively the bill simply puts that into statutory form. The criticism has been made that it's not clear what the circumstances are, but the reality is that that's the position at the moment, and it can't really be made more specific from a drafting point of view. So that's why the wording is as it is on that issue.
I wonder if I could just pick up that very last point that you've made. You said at the very start, and I think it's obvious that the law is quite complex at the moment, and part of this bill is to try to simplify the law for practitioners, but actually also for those who are tenants and those who are small businesses. But I think Section 4 and Section 5 do leave some ambiguity, and you just said there you don't think it can be drafted any clearer.
Yes, that's right.
Could you explain why you don't think it could be any clearer?
Well, in terms of Section 5 and 6, they deal with the circumstances in which the tenant remains and they're treated as if the lease is continuing, and they could be in some countries it is made clearer in the sense that there is a rule of automatic continuation if the landlord does not raise court proceedings within, say, 30 days. These rules do apply. So it could have been made clearer. We could have recommended, well, if you don't raise something within 30 days, there'll be automatic continuation. On the one hand, that would introduce a certain rigidity into the law that's not there at the moment. So a policy decision, which was taken by the Commission, was that a flexible approach should be maintained without putting in a specific date by which, if the proceedings aren't raised, the lease continues automatically with the tenant staying on.
And in regard to your consultation feedback, where were the profession, where were the practitioners on that? Are they wanting that flexibility? Was that your sense, that they wanted a bit more flexibility rather than a kind of 30-day and that's it rule?
In terms of the practitioner response, I think it'd be characterised as no difficulty with the current law in this respect. Now, maybe the current law isn't that well known, which comes back to one of my earlier points, but no one has suggested that there should be a rigid cut-off, say, 30 days, and so that we know whether the lease is continuing or not. Because there could be all sorts of reasons why a landlord doesn't want to go to court within 30 days. They could be away on holiday. Something may have happened why 30 days might not be suitable. So certainly I've not heard of anyone suggesting a rigid rule that would offer the clarity provided. It's one of these things: does one have flexibility with a bit of uncertainty, or does one go to certainty with a rigid rule?
If I could just have one more bite of the cherry, just to push a wee bit further. In regard to the kind of given notice and the new rules around that, is your view that in practice this will work quite well, and that the issues that have been raised by different parties around the complexity of it, once it actually gets going and once everyone's used to it, will actually work quite well?
I do believe it will work quite well. I think in terms of the notice provisions in particular, I think it's clear that parties can contract out if they wish of notices altogether. That may be something more frequent in the future. And if notices are required, then you know, we've got rules in there which you know, which make it clear what has to be done. So yes.
Thank you, Commissioner.
Okay, so just before I bring in Rona Mackay, so just on your comment a moment ago, with regards to the rigid rules offering no flexibility, in contrast to the common law, which does have flexibility, and certainly one of the purposes of this type of legislation and other bills that this committee has looked at is about, first of all, updating law, but also trying to respond to the change in society compared to also when the legislations were first put in place to help the economy. So with what's in the bill, and also with engagement that you have had, obviously through your work as previous as a commissioner, would this actually assist business to ensure that businesses actually can become more competitive and will certainly help Scotland's economy?
The short answer to that is it does introduce clarity, and that clarity will be found either in the lease or in the bill, and that clarity will assist businesses in planning. This is ultimately all about planning for both tenants in terms of carrying on their business at the property and landlords in terms of managing their investment and looking forward potentially beyond the existing tenant to either a fresh tenant or redevelopment or sale. So I think in terms of planning, the bill should certainly help, and that's the key. Okay,
thank you. Rona Mackay.
Thank you, Convener. Good morning. I wonder if I'd like to pick up on a couple of arguments that were made when in the committee's call for views.
Sure.
And it really follows on from my colleagues' questions. And some arguments were made that the rules in giving notice should be the same for tenants and landlords. And that differs from the approach taken in the bill. Rachel, can I ask you your opinion on that?
I think David is the expert on this. I think it would be better for him to speak to that.
That's fine. I just wondered if you wanted to comment. Yes, David.
Yes. The context is that the rules already differ in the sense that, for example, the notice coming from the landlord to the tenant must specify that the tenant remove at the termination date of the lease. That's not required for the tenant's notice to the landlord. In practice, the notices from landlord to tenant are written, and those from tenant to landlord do not need to be written. But turning to the policy reasons for maintaining a distinction, first of all, the notice from the landlord to the tenant acts not merely as a warning for the tenant to remove by a particular date, but potentially then founds an action for removing the tenant. So it has an additional role that the tenant's notice to the landlord does not have. Secondly, typically most tenants, business tenants in Scotland, will in fact be small businesses rather than larger businesses, and as such they're likely to be unrepresented at that stage when the lease is sort of coming towards an end. And to require, for example, the tenant's notice to specify the date of removal might act as a trap which could render tenant's notices potentially invalid. Thirdly, and linked in with the two previous reasons, leases for up to a year can be oral. They don't need to be written.
that I was coming on to that question. So there's some criticism of that in the call for views.
Yeah. So, and the suggestion is that all tenants' notices should be in writing, just as all landlords' notices should be in writing. But leases do not need to be, up to a year, do not need to be in writing. They could be oral. The reason for having landlords' notices in writing for those leases is because of the foundation they give to removal proceedings, court proceedings. But it seemed to us that if you have a lease for, say, a year, an oral lease, or an informal lease, and the tenant says to the landlord, "I'm leaving at the end of the lease," that should be sufficient to alert the landlord that that lease isn't going to be continuing.
Can I just clarify? So at the moment, does the tenant have to give written notice of?
No, the tenant doesn't at the moment.
So nothing changes there then?
Nothing, as a matter of law, nothing changes there.
Yeah. Thank you.
I mean, that's the position at the moment, yeah.
Thanks very much. Thank you, Convener.
Okay, thank you. Just on, as a supplementary to Rona's question, if it was a consistent approach of both tenant and landlord had to provide notice in writing, would that not provide clarity for both parties, in contrast to one can be done verbally?
I think it might provide some difficulty in the sense that the purposes of the two notices are different. I think if one could have a content that was exactly the same, there might be some force in your suggestion, but the purposes are different, and consequently the content is different, and so I think that in fact what could arise is potentially confusion. For example, if tenants are required to give a date of their departure, then that might be a different date to the date of the landlord. What the consequences of that might be unclear. Further complexity, I believe, would arise if they had if the rules had to be the same. I mean, I understand the reaction, well, why don't we just have the same rules? But then the content would have to be the same in circumstances where the message that is being given is a different message. The message from landlord to tenant is, please leave such and such a day. The tenant simply saying, well, I'm not going to be staying on. They're actually slightly different messages.
Okay. So just merely a question, not a suggestion. Okay, thank you. Katie Clark.
Yes, I've also got some questions relating to some of the points that have been raised. So what's your position on the view that's been made in some of the responses to the call for views of Section 28, which allows tenants to withhold payment if the landlord fails to notify them of the UK address?
Yeah.
So that's one of the kind of
yes,
submissions that's been made.
Indeed.
Views on that.
I mean, this is the remedy which arises where there is an obligation on parties to give each other UK addresses for the giving of notice, and this applies not just to notice to quit or notice of intention to quit to stop automatic continuation, but all termination-related notices. So it include irritancy notices and break notices where the lease comes to an end prematurely. The aim of Section 28 is to provide a remedy for the duty to give addresses that is in Section 27. The first thing to note about that is that it applies to Section 27 duty applies to leases which are over a year. So these are likely to be written leases, and if they're written, they're likely to have an address already in them. So it's unlikely in those circumstances that any duty to provide an address will actually arise. But nevertheless, there may be leases involving typically foreign parties which have a foreign address. And the question for the Commission was, well, if that duty is not complied with, what should the consequences be? This was something that to which the Commission gave very careful consideration. And the view was taken that a robust approach was appropriate to ensure that the UK address was given, and so the retention of rent where the landlord has not given their address was thought to be a sufficient compulsator, sufficient deterrent to ensure that the address actually was given. Now, the Commission appreciated the arguments of that remedy being disproportionate. Those were made by stakeholders to the Commission. I suppose the view the Commission took was that ultimately it was better if a UK address was actually provided, and that the remedy justified the aim. But ultimately it's a matter for yourself, for the Parliament, for the Scottish Parliament, MSPs to decide whether that is proportionate or not. I mean, the arguments are reasonably fairly balanced, but certainly the view of the Commission was better to err on the side of having an address supplied rather than having notices being served as a matter of form to people like the extractor of the Court of Session or, as has been suggested, the Edinburgh Gazette.
I mean, other submission that's been made, and there's been criticism in some of the call for views, relates to section 33, which requires landlords to serve irritancy notices to a tenant's creditor. And I wonder what your thoughts were on some of the points that have been made in relation to that.
Yes, in relation to that, the aim, this relates to the termination of leases prematurely, where either there's been a breach of the lease or, for example, the tenant has become insolvent. Breach of the lease typically might be non-payment of rent. Where the lease is a long lease, a mortgage can be granted by the tenant in the long lease over the lease in order to secure a loan which they've received from a lender. Now, as matters stand at the moment, the lender bears a risk that the tenant might miss some rent payments, not be aware of it, and not be made aware of the tenant's breaches, and the landlord's terminating the lease, in which case the landlord would lose their security. They'd lose, effectively, the mortgage would fly off. The house, as it were, would disappear, if I can use that analogy. So submissions were made to us that was an unsatisfactory situation, that lenders should be made aware if their security, their mortgage, as it were, is about to disappear. And that's the purpose of these provisions. Now, these provisions are not new. The Commission had recommended them in 2003 in their report on irritancy. And we can see that in the Law Society's response, which is broadly welcoming. The criticisms that were made, or that are made, are that this is an undue burden on the landlord to have to notify the lender of their intention to irritate. Now, first observation I would make is that, albeit that we've had consultation in 2003, consultation on the bill and this provision, no one has raised this undue burden point before. So it's slightly surprising to read of it. The suggestion that the duty to notify, the landlord's duty to notify the lender should arise only if there's been some notification of the lender to the landlord, think would introduce extra complexity. Has there been notification in that case? It seemed to us better to simply say, well, let's have let the landlord carry out a search of the registers to see if a security has been granted over the lease, and then on the basis of the information disclosed there, notify the lender that actually there's been breaches by the tenant and your lease may be irritated, disappear, and your security may go. So please, the lender is then open to take action to try and save that. They can try to purge it themselves and potentially even sell the lease on. Indeed, some style commercial leases have got provisions to enable that to happen. But of course, it can only happen if the lender knows that the lease is potentially about to disappear. And the cost of searching the registers did not appear to be disproportionate to the aim here, which is effectively to make leases more attractive as security for finance, for businesses to obtain finance. So in this instance, again, it doesn't appear disproportionate at all.
Thank you. And there's also been suggestions in some of the responses in the call for views that the transitional rules are likely to be a source of uncertainty for parties to leases. So could you explain how the transitional provisions in the bill work as regards commercial leases, which have already been entered into before the bill comes into force?
So when one looks at the transitional provisions, they can seem a bit forbidding at first glance. But there's a fundamental thread that runs through them, and that is a 6-month period after the bill comes into force, after the Act comes into force. So where there is a lease in existence at the time when the bill comes into force, for 6 months the existing law is saved. So in other words, the existing law in relation to contracting out, in relation to notice to quit, periods, service, etc., all of that is saved for those leases where their termination date is within the 6 months. Okay, so where the termination date is within the 6 months, it is saved. Where the termination date is beyond the 6 months, the new law will apply fully. Okay, and if, say, for example, there is a termination date within the 6 months and there is tacit relocation under the existing law to a date beyond the 6 months, then the new law will apply to that new date beyond the 6 months. So that's the key strand. The other part is that if there are express provisions in any lease, those will remain, any pre-existing lease, those will remain undisturbed.
Okay, thank you.
So,
thank you.
Thank you. Can I give out just one supplementary on sections 27 and 28?
Sure.
Does it matter if also to send something, send a document to an address within the UK? Does it matter if that address is the actual landlord or is an agent acting for the landlord?
It doesn't matter. What matters is that it's an address to which notices can be sent. That is the important thing. So a party can have an agent. A foreign party might well have an agent within the UK who can receive service. Well, they'll have an agreement that will happen, and presumably that agent will then inform them that the service has been received. But what's important is that there is an address to which the other party knows in the UK that they can serve it, to which they can serve it. I should add that I think one of the people responding, one of the firms I think responding to section 27 suggested that one of the provisions was not sufficiently clear in expressing that even if the lease requires service to be carried out abroad, the service can still be carried out in the UK. That's certainly the aim. If that section, if that subsection is unclear, then that is a matter of concern, because that is clearly the aim. It may be some drafting adjustment might be required to make that clear, but that is certainly the aim.
Okay, well, thank you. That's Burgess Salmon who we'll be hearing from.
I think indeed. So I mean, that is Burgess Salmon have made many points, and that is one of a number of valuable points.
Okay, well, thank you. Ross McCall.
Thank you again, Convener, and me again. Yeah, I'm going to do a shift to the consultation on the 1949 Act when it comes to tenancy of shops. And that conclusion then that should be repealed and amended to implement this in the bill. And then we've had that call for views that actually this should be dealt with as a separate form of legislation. What's your thoughts on that?
My thoughts are it should be dealt with in this bill, because all the consultation has taken place. The consultation is recent, and the proposal, which is straightforward repeal, can be brought technically into the bill without undue drafting. I noticed that the Scottish Grocers Federation responded suggesting that the matter be dealt with separately. Now, the Scottish Grocers Federation were invited to put in responses to the Commission's consultation on the 1949 Act. However, they were unable to do so, and indeed informed the Commission that while they had sent an email to their board of retailers asking for contributions to the consultation on the 1949 Act, they had not received sufficient feedback to allow them to put in a response to the Commission's own consultation. And that indeed had led them to think that their members had little experience of the Act or were even unaware of its existence. That last point confirms evidence the Commission has obtained from other sources as well. So in the circumstances, I would respectfully suggest that there would be no benefit in dealing with the Act separately to this bill.
Okay, thank you.
Okay, thank you. Do you have any further comments on the bill or any of the arguments which were made in responses to the committee's call for views?
Yes, thank you, Commissioner. Sorry, thank you, Convener. Yes, there is one particular matter to which I would like to draw the Commission's, the committee's attention, and that relates to Section 23, subsection 2. Section 23 has general provisions on contracting out, if I can call it that, modifying the default rules for giving notice and indeed for the periods of notice. And one of the 23.2 provides that the lease may vary the last date for giving notice under Section 13, subsection 1, by making that date earlier or later, and B, where it does so, must provide for the same day to apply to notice to quit, this is from landlord, and notice of intention to quit, that is from the tenant. The genesis of that provision was firstly a concern that the tenants should not be required to give notice of their intentions before landlords have to give notice of their intentions at the end of the lease. So in other words, that a landlord should not have an advantage in knowing what the tenant's going to be doing before they decide whether to keep the tenant on or not. So the aim was to ensure that the notice period for the tenant was did not have to be given earlier than the landlords. The second thing was that, as the law stands at the moment, the 40-day clear days applies to both landlord and tenant. So the law until now has had this sort of same date applying for both, and that influenced this provision. However, since, in particular, carrying out our consultation on the Tenancy of Shops Act, a number of stakeholders indicated to us that they would favour parties being able to contract into a situation where the landlord's notice could be given earlier than the tenant's notice. And typically, this would be where, for example, the tenant needed a licence to carry out their business, say if they were a pharmacy or if they were a pub, and would need to have extra time to obtain a licence for fresh premises to which they'd be moving. And, for example, it was suggested that in such a situation, parties might want to contract to have 6 months notice to quit and a 3-month notice of intention to quit, or maybe even a longer period of notice to quit, and a shorter period of notice of intention to quit from the tenant to the landlord. So in these circumstances, it seemed to me that this was a cogent argument for an adjustment of section 23(2) to allow the parties greater flexibility to contract for the landlord being entitled to give their notice before that coming from the tenant, provided always that the landlord would have some notice, say on 3 months. So that is a particular aspect where it seems to me that there could be improvement. In addition, there are some further drafting points from section 19 and 20 on subleases, which were raised by, I think, Law Society, Pinsent Masons and Glasgow City Council. I can go into those in a bit more detail if you'd wish.
Yes, please.
So, for example, in relation to section 19, which relates to subleases and automatic continuation, Glasgow City Council made the point that there was no reference, that the section did not refer to the possibility of a head landlord and a subtenant agreeing that the sublease would survive the end of the head lease. So the general rule is stated in section 19 that when the head lease finishes, the sublease goes with it. But there could be an agreement between the head landlord and the subtenant that, notwithstanding anything that happens to the main lease, the sublease will continue on beyond the end of the main lease. And that's a flexibility that Glasgow City Council indicated, and it's one which I see the force of. Secondly, in relation to section 20, which related to the prevention of the second type of automatic continuation with subtenants, I mentioned, we discussed earlier the possibility of the flexible position or the 30 days to raise the action. And section 20, I think, refers, this is a point made by Law Society in Pinsent Masons, refers to the action simply being raised by the main tenant against the subtenant. But of course, it could also be raised by the head tenant against the subtenant once the sublease had finished. So again, that's a drafting point which would be desirable. finally, in terms of section, I think if the Commissioner bear with me for one moment, there is another important point that was made by Urquhart's. Yeah, this is section 5(1)(b), or section 5, and the idea here in section 5 is to prevent there being automatic continuation with parties remaining, with the tenant remaining after the lease. Now, I think section section 17 makes it clear that where there are, for example, a number of landlords, a notice to quit by one landlord is sufficient to terminate the lease. That one landlord, however, would have to then potentially raise an action of removing. And the point that Urquhart's make is that section 5 or section 6 does not make it sufficiently clear that the action of removing can also be raised by only one landlord. And this represents a change to the common law which requires both landlords to raise it, as things stand at the moment. Now, that is currently, I think I could describe that as perhaps a lacuna that Urquhart's have spotted, and that is also something which can be carried out with benefit to the bill. In terms of section 24(4), trustees, there was also a suggestion by one of the solicitors responding that notification to one trustee would suffice. It might not suffice, but the aim is that notification to one trustee of a number of trustees should suffice. The reason for that is that trustees have fiduciary duties to each other, so they can be expected to inform each other of the termination of the lease. If it's just one of a number of ordinary parties who aren't trustees, there's no duty to intimate. So that's why, for that, in that situation, the intimation has to be given to all, unless they agree that just one should take it. With trustees, it's different, because there's this duty to intimate. So, again, that might require clarification, but subject to that, I have nothing further to add.
Okay, no, thank you very much. Rachel, is there anything you'd like to add?
No, thank you.
Okay, thank you. Okay, so with that, I'd like to thank you both for your helpful evidence today, and the committee may follow up in writing with any additional questions stemming from the meeting. And with that, once again, thank you very much, and I'll now suspend the meeting briefly for up to 5 minutes to allow the panel to change and for a comfort break. Thank you very much. For our second panel today, can I welcome Stephen Blaine, the Senior Associate at Pinsent Masons, Kieran Buxton, the Associate at Burgess Salmon LLP, Fergus O'Hoon, the Member of the Faculty of Advocates, and Caroline Hare, the Member of the Subcommittee on Property and Law Reform at the Law Society of Scotland. And welcome you all to the committee this morning. And just to make you aware that Rona Mackay has to leave at 11:45 if we are still in session at that point. So I'll just open the question. So first of all, do you think that the law on tacit relocation needs reforming? And if so, what are the main problems currently? We'll start with yourself first of all, Fergus.
Thank you. It's the law on tacit relocation clearly does need some level of reform. It's that there are a number of fairly well-known problems with it. Notices to quit and notices of intention to quit are served on fairly short timescales, or at least a fairly short minimum timescale, and there does seem to be a general agreement that needs to be lengthened. From a purely legal perspective, the continuing existence of the Sheriff Court Scotland Act 1907 is, to put the matter gently, unfortunate, and is actually probably at the source of a good deal of the complexity and confusion surrounding the law of tacit relocation. Is the 1907 Act. There are a number of individual areas, let us say, where tacit relocation could usefully be reformed, and those have, it's fair to say, been fairly well listed and articulated in the various consultation responses. From my perspective, they are largely matters of practice which affect businesses and solicitors more than members of faculty. So I probably should constrain my comments on that question to what I have said.
Sure. Okay, no problem. Thank you. And Caroline.
We would certainly welcome reform from the perspective of creating legislation where the law is in one place, because I think, as the previous section touched on, and a lot of the responses to consultations suggest the law at the moment is quite disparate. It's contained in common law, it's in the Sheriff Court Act. So they're definitely very helpful to create legislation which provides for that law to be accessible in one place. We believe there is still a question mark over some of the areas which cause the most practical difficulties. Interpretation require legal advice and often lead to litigation around the more subjective questions around when a lease will roll on, notwithstanding that notice has been given, will continue post this bill coming into force, because a lot of the existing issues are replicated here. And we do have a slight concern that there will be a period where we have a new law in place without the benefit of case law on the specific provisions, which we do at least have just now. But overall, it's definitely an area where we feel there is sufficient litigation and confusion to justify, certainly, reform.
Thank you. And Kieran?
Yeah, I think the general consensus that comes through from the consultation responses is, in principle, there's not really objection to reform. It becomes a question of scope and approach taken to that, and I think that's reflected in the consultation responses. I entirely take the point that from an accessibility point of view, it is important to put the law in one location. I appreciate it was mentioned in the earlier session that our consultation response noted the general point of tacit relocation to not necessarily be complex, and I just want to clarify for that. I'm speaking about giving some form of intimation 40 clear days before the end of the lease. That particular aspect can be stated fairly shortly. But I entirely appreciate that there's the wider points that are mentioned in the bill, and I think it's the breadth of the content of the bill that's maybe led to the responses that have been received in that regard.
Okay, thank you. And Stephen.
Yes, thank you. Again, large level of agreement that there is a need for reform. There are obviously issues in the detail of the bill, but Fergus mentioned litigation. Some of these cases in relation to how you end a lease do reach the level of the Inner House of the Court of Session. That isn't a cheap process, not wishing to do any of the litigators on this panel out of a job, but one of your questions in the earlier session, convener, to the Law Commission about improving the economy, etc. If there is greater certainty as to what the terms are, is it hopefully codified in a single place or expressly stated in the lease, that can only be the bit of benefit to the parties who, given the length of some leases, may not be the parties who originally negotiated it. So yes, there is a good opportunity now with this bill to reform out some of the difficulties we've faced for a century plus.
Okay, well, thank you. I think Jeremy would like to go in for a supplementary.
Yeah, I'm grateful. I mean, I wonder if I can just go back to Carol, the Law Society. So we're going to get into the detail of the bill in a moment with questions, but taking the bill holistically as an overview, do you think it goes too far? Is it too much change? I wasn't quite sure what your position was in regard to the kind of general principle of the bill. Is it too wide in its scope and needs to be pared back?
We don't think it's too wide. I think the view is there are certain sections in it which are mainly around Section 5, which I know was touched on in the previous session, which are restating the law as it stands against the backdrop that this is, perhaps, and some of my colleagues here may disagree, but a lot of the questions that come from tenants and landlords alike around the operation or otherwise of tacit relocation come from the points covered in Section 5, and we're not sure that the wording of that clause is providing any clarity. It's simply, as I say, restating the issues we have under the current law, which mean that each time one of these questions arise, a landlord or a tenant is going to have to take legal advice. And when the legislation is relatively new, those will be areas which are particularly difficult for solicitors to give precise or definitive advice on, and therefore are more likely to be questions that end up in court, as Stephen alluded to.
I just wanted to ask Stephen and Kieran, in regard to the kind of day-to-day practice, is it working? It may not be clear from an academic legal perspective, but in practice, is it working? And are we in danger of making it, in practice, for both the landlord and the tenant more complicated?
I'll go first with that. Yeah. Broadly, it works, but that is often either because people have to take advice, which isn't always the It's not always clear, even when you're asking a property lawyer or a property litigator. There's an example, I think, in our submission in answer to a different point about calculating the date or the term of the lease. It's sometimes not clear what the start date is. If the lease is then running on anniversaries of that, when is your 40 clear days? So sometimes you do have to make a judgment call to actually identify where you think the line is. And practically what happens is you can sometimes have not quite a scattergun of notices, but you can have multiple notices served just to ensure that you are, if you are, say, acting for the landlord, that you've put the tenant on notice. The recent decision, in the case of the Rockford Trilogy case, where behaviour could be sufficient to give indication of a notice of intention to quit, that added an extra complexity for the final period approaching a lease end, because in practice there may be a lease negotiation, a lease extension negotiation happening in the background. Is a tenant's position strengthened by saying, OK, I'm off, and then if it's a somewhat poorer economic market, the landlord may be thinking better to remain with someone who I've known, worked with, etc. So, yes, we get there, but it's not without its difficulties, even when you have two sophisticated landlord-tenant entities both taking advice.
Thank you.
Yeah, I might just add, first of all, I agree generally that it works. I think if you approach it as a sort of simple scenario of your client coming to you to say, I want to end the lease, and it's more than 40 clear days in advance, I think that scenario is fairly straightforward for how I would approach it, at least, which is prepare a notice to quit and make sure that is timeously served on the other party. The difficulty comes up, as Stephen's alluded to with the Rockford Trilogy case, is if you're approached as the advisor at a stage too late to give that timeous intimation, let's call it, because then there is the possibility that some form of communication that's taken place earlier could actually still be enough to exclude tacit relocation, which is what happened in the Rockford Trilogy case. So in routine matters, I think it works as it is, and then there's the element of complexity if you're approaching it after the event, in a way.
Thank you.
Okay, thank you. I'm going to hand over to Ros McCall.
Thank you, Convener. I'm going to want views on part 1 of the bill, which defines leases which the legislation will apply. What are your thoughts on that? And we'll just go right back down the line. Stephen, if I could start with you, please.
Yeah, broadly supportive. There are the excluded categories are largely all subject to their own regime, private residential tenancies, a lot of the agricultural holding provisions. I suppose there's different approaches in how Parliament approaches it. Do you have the list of exclusions, or do you say it is only a commercial, and I'm not dictating the terms, but a commercial lease that isn't one that involves student residential, grazing, etc. I know there were some, I think in Turkin-Connell's response they referred to certain pseudo-agricultural ones, or a forest would be under one situation and a nursery under another. It's not an area I've ever practiced in, so I'd defer to others. So perhaps not the final word, but in terms of having this apply to conventional commercial leases, no objection to that.
Okay, thank you. Kieran.
I'm in a similar position to Stephen. I would definitely defer to others in the consultation response who've commented on the nuances of residential and agricultural leases. In terms of the approach that the bill takes, which I've sort of referred to as definition by exclusion, which Mr. Bartos was explaining the different approaches that they thought about, I agree with that one being the one that might be best.
Okay, thank you. Caroline, thank you.
We would agree in general terms. We raised the points about the bill being clarified to make it clear that it relates only to heritable properties, so land and buildings, which I think Mr Bartos accepted. We would also question whether there should be some further consultation around exclusions raised by a few of our members in relation to telecommunications apparatus, which, while I'm absolutely no expert in that, is generally subject to its own legislative regime. And another member mentioned or raised the question of energy leases, wind farms, etc. Again, whether it would be appropriate that this legislation should apply there. So we just question whether that's something that should be considered further by the Law Commission. There was a drafting point in connection with some agricultural leases where I think the essential point of which was the same exclusion was appearing in two different sections, which might confuse you as to whether it was excluded or not, but it's a specific drafting point which I would imagine the SLC have read and considered. But generally, yes, the application to commercial leases subject to those points is we would agree with. Yeah.
Thank you. And Fergus.
Yes. Well, the faculty has taken a slightly different view of this, and generally speaking, we see part one of the bill as not necessarily creating problems, but creating a significant amount of complexity in the overall law relating to leases, because it will, in essence, create two parallel statutory regimes. The basic underlying assumption of the way that the leases to which this Act applies has been defined is that residential leases, agricultural leases, crofts, etc., they all have their own statutory regimes anyway, so you can simply assume that they don't need to be considered. And in one sense, that's true. Crofts have a very particular regime. For example, so do the various forms of agricultural tenancy. But once you strip back the layers of the statutory regimes, you find, sitting underneath it all, tacit relocation. To give one example, which we referred to in our response, the Agricultural Holdings Act of 1991, which deals with the majority of agricultural leases in Scotland, provides for explicitly provides for continuation of the lease in Section 3 of that Act. But if you actually look at Section 3, what it says is a lease continues by tacit relocation. It's nothing other than a declaration that the common law applies. And the tacit relocation that Section 3 imports is the common law of tacit relocation. It doesn't have its own rules, and as the inner house of the Court of Session has continued to develop the law of tacit relocation, that continuing development applies to the law that applies to 91 Act tenancies. Similar points are made in relation to crofts, to a very significant proportion of a proportion anyway of residential tenancies. PRTs are slightly changing the field on that, but even there, a PRT can have a defined end date, and if it does, tacit relocation will apply. Those regimes create security of tenure essentially by significantly limiting the situations in which a landlord can serve notice to quit, and effectively then force tacit relocation to renew the lease for another year. So, looked at properly, a 91 Act agricultural tenancy, for example, is just a lease continuing year to year on tacit relocation. There are strict rules about when notices to quit can be served, but underlying, if you strip that away and just look at how the lease is renewed, it's the common law tacit relocation. It's not a statutory scheme all of its own. That wouldn't be a problem if the approach that had been taken in the bill was to make a couple of minor piecemeal changes which just applied to a particular set of circumstances. Nor would it be a problem if the bill had said these are our general problems with tacit relocation, which service of notices, for example, and had made a universal rule that notices to quit need to be served at least 3 months or 6 months in all notices, unless there is a specific statutory provision saying otherwise, as there would be in the 91 Act tenancy. Because the decision has been taken instead to codify tacit relocation into a new thing called automatic continuation, the effect of Section 1 of the bill is to create two parallel regimes. One which applies to a residuary category of agricultural leases, crofts, houses, and so on, and one that applies to everything else. Those two regimes are similar, but they're not the same. It is likely that over time, as this bill or this act is considered by the courts, those regimes will diverge. Deciding whether a lease falls into one or other of those regimes is not necessarily going to be straightforward, because leases can fall in and out of the various statutory regimes which are excluded from this act. It is possible for a 1991 Act agricultural tenancy to become a commercial tenancy. It doesn't happen very often, but it is perfectly possible. And if you have two regimes, you have the potential for notice to quit being served validly under one regime, but not under the other, and then arguments as to what applies.
Okay.
That is, at its heart, our concern about about Part 1, and it feeds through to the general concern that we note in our submission that whilst a reform of tacit relocation is probably welcome, a codification of it is perhaps not the right way of going about that reform.
Okay, that's been very interesting. Thank you very much. Of course.
Carolyn mentioned leases under the Electronic Communications Code. I think this committee of the Parliament should just reflect on the interaction of those two regimes, if I may say. Your mobile phone masts on the roof of a building or in a field, they're governed by the code which is in the Digital Economy Act 2017 as updated. The code agreement, as it's referred to in the Electronic Communications Code, is often a lease in Scotland. But because the Westminster Parliament took the view that the provision of electronic communication services to the general public it's nigh on a utility, it's a public good, there are very specific and limited grounds in which a landlord can effectively terminate and then remove under the code agreement. the fact that some of them are leases could add an extra complexity to the existing rules that require the involvement in Scotland of the Lands Tribunal for Scotland in terms of managing the renewal or termination of these, what might be referred to as code leases. But so there is just, it was one specific regime I did just want to flag because it's already got its own levels of complexity.
Okay, thank you. So, because obviously part of my issue being representing a rural area is the rural concerns that are coming in. That's all been alluded to, and I accept wholeheartedly that that's not maybe your field, and if you excuse the pun, don't want to get involved in that. But that tightening up, are you all saying that that is essential, and that this the sort of tightening up of the definitions is going to be essential in stage 1? Yes, no. Simple yes or no answer would be yeah.
Sorry, I will defer to others on that.
We definitely think it should be reconsider some of the specific points, right?
That's great. Thank you very much. Thank you, Convener.
Thank you. Chairman Belfer.
Yep. Thank you, and again, thank you all for coming along this morning. I suppose I want to go back to where I think Carolyn kind of was commenting on in regard to particularly sections 4 and 5 of the bill. I think you and others have expressed that there is too much ambiguity or unclarity in regard to the drafting. I suppose if you're not happy with the drafting as it is, what would you like to see there in its place? And maybe start with the Law Society first, if that's all right.
One first point in connection with section 4, I think Professor Bartos referred to in the earlier session that the law as it stands just now is not absolutely clear that parties can contract out of tacit relocation and leases, albeit this is something that's done. Section 4 at the moment, as we understand it, creates a situation where a party a pre-commencement lease may purport to include wording excluding tacit relocation, so the party's intention being that the lease should not continue beyond the contractual expiry date, but find itself caught by automatic continuation in terms of this Act because of the wording of section 4. So we would just question whether it would be helpful to clarify in this bill that it is valid to contract out of tacit relocation, and in turn, if that is something parties have done, that lease should not be subject to automatic continuation. That's just a question. We think that would be helpful, or could be helpful. Does anyone else want to comment on section 4 before section 5? No. Section 5 is probably best spoken to by the litigators on the committee here, but our main concern is the wording, the subjectivity of the wording in section 5. What steps the landlord has to take, timescales. These are all questions that, I heard the previous evidence, we can understand the rationale there, but a big benefit, if we are going to codify this area of the law, would be to create more certainty. I think that should be one of the, or we believe that should be one of the main benefits of codifying the law. And as I mentioned earlier, there is a concern that section 5 here is simply restating a lot of the common law position, which in turn requires interpretation by solicitors.
I mean, just on that then, and others can pick this up. So we heard that in other jurisdictions there is a much more fixed way of doing it. You have a 30-day period. Not necessarily from a practitioner's, but from your client's perspective, would that be too far a change within the law?
I would need to take that back. I don't have a view from our members on precise actual timescales, but as a general policy position, our view would be the clearer or more concise it could be. Certainly from the giving of a legal advice perspective, that is a much easier way to give definitive advice than opinion.
I perhaps
yep.
could, currently, if a lease comes to an end, and there are situations where a lease can come to an end without notice to quit. If a lease comes to an end and the parties don't realise, happens, for example, when a tenant might die or something similar, and the parties don't realise, and the tenant remains in possession, and the landlord continues to accept rent, then the rule the rule which applies was stated by the House of Lords in the 1980s in a case called Morrison Lowe against Patterson. A new lease is effectively created. And really, the test at the moment is, does the tenant stay in possession with the knowledge of the landlord, with the knowledge and consent of the landlord, and has the landlord accepted rent? And if those three things are established, then a new lease, for an unwritten lease for 1 year, on, so far as possible, the same terms as the previous lease, comes into existence at that point. Section 5 is effectively just importing that, except that it makes it a continuation of the previous lease rather than a new lease. Arguably, Section 5 is actually slightly unclearer than the current law, because instead of these three broad criteria, it has a simple the landlord not taking steps to remove the tenant from the subjects within a reasonable period. Something like accepting rent might perhaps be a more objective test. That the only point that I would make there. I certainly would agree that whenever you see something in a bill like within a reasonable period, that is a sign that litigation will follow. Sure as night follows day.
Kieran?
I agree with that point. I wonder if one way maybe to balance that is to give examples of ways that a landlord might act inconsistently, one being the acceptance of rent after the relevant period without, well, I think they would have to give it back again, or as an example of how to try and provide more certainty without necessarily changing the principle of stating these quite general level paragraphs to the alternative which was discussed, like, for example, the 30 days being the more certain. The statutory analogy that I would draw there with sort of giving examples to fit a general principle, I think section 52 or 53 of the Title Conditions Scotland Act, when you're trying to figure out what a common scheme is, has sort of examples of how you might, or what factors you might look for in determining whether the test is met. So I just suggest that as some alternative that might balance the competing suggestions.
Stephen?
I think the earlier question about how it works in practice, this would be the new question. What's a reasonable period? What does acting inconsistently mean? Without the examples and the guidance from the court, which would come with time, I imagine, particularly in relation to this section, you probably would be taking a little bit of a step back in terms of ability to properly advise clients, because at the moment we all probably have a feel for how it works in practice. Sometimes you wouldn't immediately be raising removal proceedings in the court. Sometimes you might be ready for the day after the lease ends for various commercial reasons. I do think that Clause 5, as currently, would be one that would generate litigation in the short term, because it's just crying out for an unscrupulous tenant to take those statutory defences and then, depending on their particular circumstances, then appeal that decision.
So I appreciate any of you are a judiciary, and you may regret answering this question, but within a one sentence, what would you define a reasonable time? If you were advising a client coming in today, what is a reasonable? How would you define it to a client?
It's not going to be one sentence, I'm afraid, because it will always depend. Is this a 1 year?
Well, let's just say we are trying to redraft this section within the bill, and we want to take out the word reasonable time and put in a period of time, a week, 2 days, 10 days, 30 days, whatever. Would you have a period that you would feel would define reasonable?
I think if you were to be putting a period in, then it would say 28 days. And the only reason I say that, not to advocate for that specific time, but that would then be your trigger. Do I raise court proceedings before then? I've got a window to be able to negotiate potentially, and there are a number of types of court action, not just in relation to property, that have to be raised within a statutory period provided in the particular legislation. I wouldn't necessarily say 28 days would always be reasonable, but I think Parliament would have to come up with a figure, and then it's clear on the face of the bill that the landlord potentially has problems if they haven't raised litigation with it on the 29th day.
I mean, we may seek to amend this. I'm just trying to get from practitioners some expertise. But if I put down, say at stage 2, 28 days, 30 days, 50 days, from a practitioner's perspective, what would be reasonable?
28 days would allow a reasonable period, for the client to consult with their lawyers and for the necessary papers to be drafted. 7 days could easily be missed because of people not being aware what the termination date was. 14 days is problematic when you have the Christmas holiday or in the summer. You're then getting to 21 or 28. No strong views. I've said 28, so I'll stick with that.
Can I just go, Ryan, would you be happy with 28, Kieran?
Yeah, 28 or 30, that range seems to me to be reasonable. I suppose the prior question might be to make sure everyone is thinking the same on what steps to remove are. And I mean, I assume we're all thinking of raising a court action for removal. Because I think some of the consultation responses possibly asked whether that meant just writing with a demand to remove. Now, would that count as a step to remove, or are we speaking about actually raising proceedings? So I think some certainty on that. But if that were to be understood as raising court proceedings, then I think 30 days, 28, 30 days would be a fair reflection.
I appreciate you haven't consulted with your members. You may not want to answer this question, Karen.
No, we would need to consult.
And I don't know if the faculty have a view.
My concern with 5.1b at the moment, and I don't think that it would be particularly altered by putting in 28 days or 21 days or whatever, is that is exactly the point that Kieran's just raised, which is steps to remove the tenant realistically is likely to be interpreted as the raising of proceedings in the Sheriff Court for removal. And without wishing to do myself and my colleagues out of work, that does funnel people towards litigation in a way that the current law doesn't necessarily. An approach which focused on objective criteria like the acceptance of rent, for example, would mean that parties weren't feeling themselves butting up against a time limit beyond which the lease would continue, and that would perhaps allow for situations in which a tenant and landlord might agree that the tenant has a month to remove its stuff, for example, or without needing to worry about whether Section 5 has erected a new lease in the meantime, which might would not necessarily be what either party wanted.
Okay, so just to move us on a wee bit quicker, obviously, we all understand, and I think it's becoming very clear this morning, that this is a really complicated area, piece of law at the moment. Does this bit, what other parts of the bill do you think are overcomplicated, and could they be simplified?
Happy to start with that. One of the, and apologies, this was leaping into a different part, the provisions prescribing how notices are to be served and how, in what form, by what method, I think is potentially creating an issue for the future. There are, we would be creating a notice code on how to serve notices to quit and notices of intention to quit. Some of that would be inconsistent with the common law, and we give an example in our response about faxes. They would be treated as electronic in this Act, but they would be treated as writing at common law. I think if the Law Commission wishes to review the law of notices, and there is then a notice code for everything, that would perhaps be a better approach, because the issue you will then have is under a lease you may have to give notice in relation to alterations that have taken place. You may have to give notice as a landlord to a tenant to comply with a particular provision. There's obviously the irritancy regime as well. All of a sudden you would be having two notice regimes based on the same contractual arrangement. So I think the prescriptive method of giving notices in the bill here should be reflected upon.
Before I bring others in, are faxes still commonly used in legal activity?
Certainly the firm still has a fax machine, and for something like this, they can be incredibly. They still are allowed under the Sheriff Court and the Court of Session rules. I imagine there aren't many members of the public who will be looking to replace their fax machine when it finally gives up the ghost, but it can be exceptionally effective because it is a way to give written notice that day when you aren't actually physically in the same place. So until the fax machine finally gives up the ghost, then it is a method of giving notice, and I personally have given advice in relation to just fax it.
Okay, thank you. Kieran?
I would echo that provision for the slightly different reasons that are set out in our consultation response. I'm conscious that we're looking to save time, so this is quite, I suppose, involved point, but basically the bill's notices provisions are there, but then there's the sort of residual clause 23, subparagraph 5, I think, which basically says if an existing lease is inconsistent but does not expressly vary a provision or something that's contained in the bill that can be varied, because of course there's the mandatory clauses in the bill, then there might be a question about whether the clause of the lease about notices, and it's very common to have notices clauses in leases, and they will usually provide for when delivery or when service is deemed to have taken effect, like 48 hours after the time of posting, and set out what needs to be proved for that presumption to be engaged. there's case law which isn't entirely consistent about whether that can be rebutted or not. But if it was the case that a notice under a lease, served under a lease, is treated as served 48 hours after it's posted, the question would be whether that is inconsistent with the bill, because the bill basically provides for the date on which it's treated as being received as capable of being rebutted by contrary evidence. So I think there's potentially scope for litigation there in that scenario. That's the one that I would add, but it's probably better to read the consultation response rather than me try to explain it in the compressed time that we have on that front.
Thank you. Caroline?
I think the colleagues here have expressed very well some of the concerns around the forms of notices. We have a very kind of general question in connection with electronic communications. We think it would be beneficial for this to be looked at again in some more detail. It's worth noting that what we call the PSG style lease, so it's a style lease which is generally accepted as an agreed form, on a basis for an agreed form commercial lease in Scotland, doesn't as standard provide for electronic service of notices because of the perceived issues around that just now. So we would just query whether the provisions in the bill as they are should stand. There are some more practical queries around the detail of what is an electronic communication, what is writing in an electronic sense. Is it a signed PDF attached to an email? Is it a QES signed? So as a general point, we would question whether those provisions specifically should be looked at a bit more carefully.
Okay, thank you. And Fergus?
Yes, the faculty in its response did express, which I think Stephen has already said, very considerable concern about creating a sub-code for the service of notices in relation to ending leases. The law on service of notices is actually quite well developed, and since since the House of Lords, let's say in the 1990s, in a case called Manai Investment Company, the basic rules relating to service of notices in Scotland are pretty clear, and they apply to notices served under leases, notices served under contracts more generally, covering a wide range of commercial activity in Scotland. And it's not clear to us that hiving off the termination of leases from that general law would be a sensible way to legislate. It's worth remembering that, as a general principle, particularly in a system like Scots law, which has a lot of influence from Roman law, the preference is to have general rules that apply to a variety of situations rather than having specific rules applying to specific situations. In other words, if you want to serve a notice under a lease, you look to the general law regarding service of notices rather than to particular rules regarding service of notices in a particular in leases. That's the heart of the sort of the basic structure of Scots law, which we teach to students in the first year. And if the law relating to service of notices needs to be changed and reformed and updated to take account of emails and so on, that is one thing. But to come at it in this piecemeal way strikes us as undesirable and again likely to result in increased litigation for no particularly good purpose. The desire to have everything in one place for ending leases is a laudable one, but it's not necessarily consonant with maintaining Scots law as a coherent system of legal principles overall. And we do in our response refer to one or two specific criticisms that we have of the proposed code. It is more rigid than the current common law. In one sense, that reduces potential for litigation because if the law is rigid, then there's much less scope for arguing about whether a notice is served incorrectly. On the other hand, rigidity means that people are more likely to fall on one side or the other accidentally, and be unable, and the law is unable to take account of that. So I think we specifically mentioned the time by which a notice must be served. So I think that's in section 8 or clause 8 of the bill, where you get a period of 7 days. If the notice to quit is served against a date which is 2 or 3 days, or anything up to 7 days after the actual termination date, then that notice can still be effective. That is much more rigid than the existing rules, which would probably allow for what you might call fat finger errors, whereby, let's say, in a month, a 6 is substituted for a 5, and so a notice to quit accidentally served against the 30th of May rather than the 30th of April would probably be effective under the existing rules and would not be effective under this. So we do have one or two specific criticisms to make, but the more general criticism is a concern about the wisdom of codifying notices in general.
Okay, no, thank you. Thank you. Rona Mackay.
Thank you, Convener. Good morning. I was going to ask you the same question I asked David Bartos about responses to the call for views, in which some arguments were made about tenants and landlords having the same, be given the same time, and also whether oral ending of lease could be given by a tenant who has less than a lease of less than 1 year. I'm not really going to ask you, because I think I've gathered from what you've been saying what the answers to that are. I am mindful that David Bartos said that on one of them, and I can't remember which one, there was no change. Because I said something about, but does that not happen just now? Does the landlord not have to give written notice? And he said yes. So in that sense, nothing changes on that particular aspect. Am I correct in that, or am I getting confused?
Sorry. So at present, my understanding certainly is the landlord's intimation that tacit relocation will be excluded does not need to be in writing. Is that your understanding?
I think if I could characterise it this way, if things haven't, if the bill is being presented as things haven't changed, I would caution. But it was
just on that one aspect.
No, but on that specific aspect, yeah. Yes, there may have been good reason why historically in the past oral notice was sufficient, But the immediate problem with that in the 21st century is you could WhatsApp, you could email. There are various ways that you could actually have a dated communication. And an oral notice immediately begs the question of who said what when.
That's what I had thought as well. Yeah, no, that makes
So
sense.
Yes, it may be reform, but I would encourage that even for the unwritten lease scenario.
Yeah, because we all like to have something to look at that we've said or agreed to, I guess. And then just finally, I mean, I'm getting the impression from what you're saying about this particular aspect about notice that it could create more litigious tenants. Does it give them opportunity to say, well, you know, that's not right, I'm going to take this further? Do you think the bill as it stands, that this could happen?
I think the point that I would make about that, coming back to so the area that I was just explaining in the last question was in our response it's question 5 and then paragraph 4, but the area where I think there's scope for litigation is as to which regime applies for when the notice is treated as being received. Now, I appreciate what Fergus has said, that under the lease there will typically be a clause that sets out when a notice is deemed to be received, and that could be conclusive, i.e. it's treated as being received on that date, whereas under this bill there's wording that says unless the contrary is proved, which would allow you to suggest, well, I didn't get it on that day that it's deemed to be received under the lease.
So that could be disputed.
So, and if you're really up against the deadline, then that might be the difference between it being timeous or not timeous. I should say that the case law that I mentioned in that answer, that question is probably still a live one that could be resolved even based on the current law, because there's kind of competing decisions. So it wouldn't necessarily introduce new litigation, but it's just through a different vehicle.
I think, Fergus, you spoke to about litigation being more possible in certain circumstances.
I mean, as a general rule, if there is any ambiguity or question to be answered, a tenant or indeed a landlord who wants to maintain the lease or end the lease will be encouraged will be incentivised, let's say, to grab onto that ambiguity as the grounds for an action, not necessarily to run the action all the way to its conclusion, but to force a commercial settlement on more preferable grounds to them than they might otherwise have received.
And preferable to them than the tenant to do it. Do you know, I'm trying to get an idea of who would have what the power balance would be.
The power balance, if I may, it will always be fact specific, because if you are an individual landlord family company in rural town high street in Scotland and have a mini supermarket as your tenant, that's great because they've got an excellent covenant, but they could perhaps afford to take advice or push things a little further. Flip side of that, if you're a small business and you expand into a small unit in a shopping centre that's owned by a multinational investment fund, again the dynamic changes. So there's not one. The David versus Goliath will always be fact specific depending on what the unit is and who the respective landlord and tenant are.
Yeah, understand. Thank you. Thank you. Sorry, on you.
Yeah, it just means that commercial leases are different from residential in that respect. Is you cannot assume that the tenant is in the weaker position. Always, it would not be at all uncommon for the tenant to be in the stronger position, and indeed one of the main unsatisfactory elements of, for example, the Tenancy of Shops Act 1949 is that it is largely, it would appear, taken advantage of by Tesco and Sainsbury's, not by the small shopkeepers that it was intended to benefit.
Okay, that's interesting. Thank you. Thanks, Convener.
Thank you. And Katie Clark.
Thank you. And I was wanting to ask what your position is on some of the criticisms that were made in responses to the call for views. Same questions as asked the previous panel. So in relation to section 28 of the bill, which allows tenants to withhold payment if the landlord fails to notify them of the UK address, there has been some criticism, and you'll have probably heard the evidence from the last panel from David Bartos. And I just wondered what your thoughts were on that. And, you know, is it right that there should be a UK address? Or do we, you know, if it's just a registered office, a plaque on the wall, is that pretty meaningless? And do we need to know really where the landlord is? I just wonder what your thoughts were on that.
I have no issue with there being a requirement for a UK address. That, again, will be a provision that will be in a lot of leases. However, I think the suspension of rent is entirely disproportionate. Right. The point I made earlier, the leases can change, parties can change, and I think if the requirement is to protect a tenant from having to do expensive in-person service, say in the EU, America, whatever, to serve their notice, then there are other ways that Parliament can express its view. And the example we gave in our response is a notice in the Edinburgh Gazette. The suspending the rent could have implications further up the line, because if the landlord has a security and the rent is paid quarterly, for example, then through an administrative error, they could then be in default of their security. That will then change the dynamic with the tenant. So if there is a view that there should be a UK address, because that then allows recorded livery and such things to be used as the method of service, suspending the rent, if that isn't complied with, to me is entirely disproportionate. Okay.
Thank you. Is there any other witness that has any views on that particular issue, Kieran?
Can I maybe pick up just on section 27, which is the one that's imposing the UK address? I'm conscious that Mr Bartos had mentioned a consultation response, which was our one, about the drafting not necessarily being clear. As I understand it, the aim being, if this UK address is notified, there is no requirement for the other party to also send it to the non-UK address. Now, when I read 27.1 and 27.5 together, I'm kind of seeing it, but my concern is that it's not clear enough, in particular the bracketed text at the end of 27.5. I think that if there is an address notified under 27.1, if it can be more clearly stated that the other party need only send the document to that address and does not require to send it to any other address out with the UK that may be required in the lease, you know, just making it a bit more express rather than is not invalid only by reason of such an enactment. I just don't think that goes far enough to achieve the aim. And then as to the remedy, I'm conscious we didn't express a view in our response on that. The only point I would flag, picking up on Stephen's point about looking further down the line, another issue might be diligence being carried out for unpaid rent, because if the tenant was entitled to withhold the rent and there hasn't been a sort of communication about that, that's a scenario in which the diligence might be wrongful, because the tenant would have had a right to withhold the rent. So that was just another sort of potential unintended consequence to flag.
Okay, thank you. And another criticism in some of the responses was in relation to section 33 of the bill, which requires landlords to serve irritancy notices to a tenant's creditor. So that's section 30, subsection 3 of the bill. I don't know if any of the witnesses have a view in relation to that or agree with the criticisms that have been made. Caroline?
only comment was that in circumstances where the landlord wasn't required to give consent to the grant of a security by the tenant should notify the landlord of any securities that they have granted. We thought that would just be helpful. In practice, a landlord would likely, with a registered recorded lease, be carrying out a search to confirm who the tenant was anyway, which should in turn disclose a standard security or a mortgage. But we did think in that one scenario where the tenant can unilaterally grant the security without reference to the landlord, they should be obliged to. It would be helpful if they could notify the landlord at the time.
From our point of view, it's providing a legislative protection for a party who isn't part of the contract. At least it's a contract at the end of the day. If the tenant has a security and has financial issues that might then also impact that security, the onus is on them. The landlord should be entitled to recover possession if they aren't having their rent paid, and the heritable creditor has the relationship with the tenant, not with the landlord.
Okay, thank you. And my final question relates to the transitional provisions. There has been a suggestion from some that the transitional provisions are uncertain or could lead to uncertainty. So could you maybe give your views as to whether you think the transitional provisions as they stand are likely to lead to uncertainty or are problematic, or whether you feel that they're perfectly reasonable as set out by the previous panel? I don't know if any of the witnesses have a view in relation to that.
We didn't. We didn't mention it in our consultation response that I can see looking back. Having said that, the transitional provisions are always complex. They are frequently a source of litigation, and it might well be simply to provide that this bill applies only to leases entered into after after its commencement. Yes, that is the only thing I would say.
Okay, thank you.
One word answer. As Fergus said, yes, look ahead. Don't try and innovate on what could be quite complex commercial arrangements that are already in place.
Sure. Did other witnesses agree with that or not have a view?
I wish I'd thought about that at the time, because I wrote about that in my consultation response, but I was approaching it as if the bill was being implemented as is, so with the aim of looking back to some degree. I can entirely see the benefit of the approach that's been suggested. What I would say about the response that we put in on that, my issue, the principle of it is that the word notice is used in an undefined way through paragraph 8 of part 2 of the schedule. Now, I did make a suggested way to resolve that. Having sat and read it again multiple times, I'm not necessarily sure the proposed way I suggest would be the best, but, and this maybe highlights the problem or the inherent complexities in transitional provisions, but the concern essentially is using the word notice in relation to essentially the pre-commencement law, where we're using notice in the bill in other sections to mean different things, and it's also defined in paragraph 8, subparagraph 11, only for the purpose of subparagraph 10. So I think that if transitional provisions are to remain about this, that it could certainly be more succinctly put. I think the reason why the word notice is in there is understandably from a draftsperson's perspective to tie into clause 3.1 and section 2 of the bill. But that's really the kind of key issue that I identified. The one other point I would flag that I noticed in, I think, Shepherd and Wedderburn's response was about paragraph 8, subparagraph 2, which was basically saying or asking to clarify if a lease is continuing by tacit relocation from commencement day, and it continues to do so for more than 1 year, is it until it's ended that it's still under the pre-commencement law? So that could be, 5 years after. So that's one point that I think is definitely worth clarifying within that paragraph. The one point I would say about the wording of their response was they'd sort of suggested, does the pre-commencement law run until that lease is terminated? That might not necessarily be the case, because it might run on tacit for 2 or 3 years and then it's varied. So then there's a contractual end date put in, and at that point it wouldn't be running on tacit because it would have been varied. So maybe that's just emphasising the point that Fergus very briefly made.
From the Law Society's perspective, absolutely anything to simplify transitional provisions would be helpful. I think to your point, Kieran or Mr. Buxton, I think David Bartos touched on that point in previous evidence, and his view, and I might be incorrect, but his view was that tacit would apply and then the new law would kick in. But I agree, Shepherd and Wedderburn had raised the point that and the wording isn't quite clear, so I think we'd need to check. But I did pick that up in the earlier session because I was aware of the point you mentioned. So I think the view is SLC are in agreement that that's how it should work, but the clause perhaps isn't as clear as they think.
Thank you very much.
Thank you. And Ross McCall.
Thank you. What's your view on whether the Tenancy of Scotland Act 1949 should be repealed and the bill amended to implement it? Now, you've already brought that in, Fergus, so have you got anything additional to add? And I'll see what the rest have got to say.
The Tenancy of Scotland Act is large. It's a fairly elderly piece of legislation. The problems that it creates are largely matters of practice, not matters of law. It is itself, as I understand it, relatively straightforward to apply. Not that I have ever had to do so. The faculty has said that if a decision is taken to appeal the 1949 Act, then it could perfectly well be done in this bill. I would certainly adhere to that position. The faculty makes no comment on whether or not it should be.
Okay. Thank you. Caroline? Yeah.
Same from our perspective. I have no views on whether or not it should be repealed, but our view is that if the decision is made that it should be, it would be our preference that is covered.
Okay, excellent. Kieran?
I would agree with those comments.
Repeal and include.
Wow, that was easy. I don't normally get a question like that. That's fine.
Okay, it's a brief.
Yep.
Okay, Jeremy.
I wonder if I can come back to you in regards to... I'm a wee bit confused on where the faculty of advocates are with this bill. Are you wanting it rewritten, withdrawn and thought about again? Or I appreciate you want some amendment, but I'm not quite sure. Are you wanting it fundamentally rewritten or fundamentally withdrawn and start again? Because I'm a wee bit unsure where the faculty are on this.
I think that the general tenor of our response is that a rethink or a different approach might be preferable. That tacit relocation, if it is to be reformed, if it is to be renamed or whatever, should be done in a way that that doesn't leave elements of the common law in existence in the long term, and also that it would have been better to separate out the parts of the bill which relate to tacit relocation proper and those that do not and are simply elements of broader rules of law, where there is no particular benefit to be derived from hiving off this particular area from those broader areas of Scots law. The one other thing I would say to that whilst my microphone is on is it's worth also remembering that Scotland is not a large legal jurisdiction, and the number of cases that actually go all the way, to the inner house of the Court of Session and from there onto the Supreme Court is relatively few. If you have a single area of law which covers a wide range of situations, you are more likely to get development of that than if you have a very narrow set of rules related to just leases, where the court might only consider it once or twice or three times in the next 50 years. That really would not actually be particularly uncommon, at least to get high-level authoritative decisions relating to the legislation. So you are also potentially preserving ambiguities for a longer period of time if you hive off areas into their own little silos.
Thank you.
Thanks. Ros?
Okay, now the awareness-raising campaign. What are your views on the call for evidence that came in, that responses that the Scottish Government should carry out that awareness-raising campaign to make sure that it's understood across all affected sectors? And we'll go the other way down the line. Stephen, we'll start with yourself again.
If it was the bill as proposed that was enacted, then yes, I think there would be value in that. The point of caution I would make to the parliamentarians at that end of the committee is awareness raising doesn't change the law. So yes, we need to highlight it, but it's got to be right on the four corners of the legislation. But yes, there will be firms such as Self and Kieran's. We would be talking about it internally, we'd be talking about it with clients, but to go back to one of my earlier answers, the small independent landlord in rural town high street would probably benefit from some sort of government nudge about it.
Okay. Thank you. Kieran?
I would agree as to the methods. Obviously, I suppose it would be some element of business development for articles, etc. But also noting some of the respondents to the consultation being sort of trade organisations. I think coordination through those to try and get the message as wide as possible would presumably be of benefit with a sort of leaflet.
Thank you.
Absolutely. The Society's view is that there would be a requirement for an advertisement and a widespread education as far as sensible in the terms of the new legislation, whichever form it eventually takes. Yeah.
Thank you.
Nothing useful to add to any of that.
Okay, that's brilliant. Thank you. Thank you, Convener.
Okay, thank you. I want to thank the panel for your helpful evidence this morning, and certainly the committee may follow up in writing with yourselves if you've got any further questions, but also if there are any other points that you would like to put in the record, if you can please do so in writing with regards to the bill. That would be very helpful. So with that, once again, thank you very much, and this now concludes the public part of the meeting, and I'll move the committee into private. Thank you.